Gentlemen of the jury, on April 26, 1984, the plaintiff in this action received personal injuries as the result of the explosion of a gas range. He claims that these injuries were caused without any negligence of his own contributing and solely through the negligence of the defendant. The defendant denies those two claims. The plaintiff's claims and the defendant's denials constitute the two issues in this case which are to be submitted to you for your determination. That means to make an end of the dispute within the evidence. You will do it by applying the rule of preponderance of the evidence. Those words relate not to the number of witnesses nor to the volume of the testimony, but rather to the quality of the testimony. You will judge the quality of the testimony by applying a few familiar tests. One of them is the rule regarding interested witnesses. Of course, the plaintiff is an interested witness as a matter of law, and so also are the witnesses now in the employ of the defendant, interested witnesses as a matter of law. It remains for you to say whether any other witness in the case is interested as a matter of fact. It does not follow, however, that because a witness is interested as a matter of law, you are to disregard all his testimony. It follows only that you are to take note of the interest and judge for yourselves how much value is lost to the testimony. Another test to apply in judging the quality of the testimony is the rule regarding false testimony. That is more severe. If you find that the plaintiff or any witness in the case testified falsely on a material fact, then you may disregard all that testimony. Then there is the test of probability, a test more familiar to you. You probably apply it every day in your business or vocation. It has taken the better part of 2 days to hear how this thing happened, and yet it took only a few seconds for it to happen. There are two conflicting versions as to how it happened. After you have applied these tests and selected the credible evidence in the case, then place it in the scales of your minds, and at that point, remember that the burden is on the plaintiff to satisfy you that the explosion occurred as he claims, and that it was because of the defendant's negligence. The burden is noted on the defendant to satisfy you that the explosion occurred as the defendant claims. According to the plaintiff's version, he was a cook employed at this place, and he was preparing some food, and he wanted to use the oven in the gas range. So he undertook to light the gas in the oven by applying a match flame to the pilot light, which would ignite the gas inside the oven. Then he went away to do something and returned presently, and the explosion occurred. He would have you believe that from that the burner was defective in the oven, and that after having lighted it and turned it on, because of this defect, the light went out. And after he had returned, following an interval of 15 minutes or something like that, there was as much gas in the oven that it became ignited and exploded. It would appear from the defendant's testimony that he smelled the gas and started to shut it off, as he had on other occasions prior to this occasion, but that he did not get there in time to do it, that he was stopping to do it at or near the range when the explosion occurred, blew out the oven door of the gas range, and injured him in the face and other parts of the body. According to the defendant's version, based in part upon alleged admissions of the plaintiff himself soon after the accident, before he brought any action to recover damages, before he had an opportunity, or before he had such an afterthought, he told his former employee that he started to light the oven, turned on the gas, and then when he came back, he supposed that the escaping gas had filled the oven to such an extent that it ignited from the top burners and exploded. That, of course, is only a brief outline, and it is for you to fill in the outline of both plaintiffs' and defendants' versions as to what happened. The burden is upon the plaintiff to satisfy you. I repeat, that is his version as to how it happened is the correct version. then it remains for you to determine whether the defendant was negligent in the premises and the plaintiff free from negligence. But unless the plaintiff has satisfied you at the outset by a preponderance of the evidence that his version as to how it happened is the true version, it was